court found that the President's action in attempting to block the release of the report amounted to what they described as an abuse of the judicial process and an attempt to stymie the fulfillment of a constitutional obligation by the Office of the Public Protector. Moreover, the court found that the review process, the second judgment, was a, quote, clear non-starter, and the President was, quote, seriously reckless in pursuing it as he has done. This conduct, the court found, falls far short of the standard expressed in Section 195 of the Constitution. As South Africans, it should concern us that this reckless litigation was the first time in our constitutional history that a sitting president has been required to pay back personally the costs of litigation out of his or her own pocket. It is thus the mark of a president who has solely been, up until now, focused on personal gain and not on the interests of the people and the country, and not on the upholding of the rule of law and the strengthening of the Constitution.
In a matter brought by the EFF, DA, COPE, UDM, which seeks to establish the procedure to be followed in the impeachment proceedings against the President. We have the view that this case is vitally important as the Constitutional Court has the opportunity to provide guidelines for clear and proper procedure of impeachment proceedings, which will allow for those who break their oath of office to be held to account. These rules also ensure that no one party can use their majority to frustrate impeachment proceedings, as we've seen the ANC do. They should also provide for the opportunity, for instance, for the President to provide evidence in his or her defense or mitigation. These rules also should ensure that once the application is finalized, we'll then consider this impeachment motion in terms of Section 89, 1A of the Constitution. Yesterday's judgment shows, in addition to the damning findings of the Public Protector made against Jacob Zuma, in her state of capture report, a number of substantial adverse findings may be against the President, including that the President's conduct in trying to block the release of the Public Protector's state of capture was an abuse of judicial process, an attempt to stymie the fulfillment of the constitutional obligation by the Office of the Public Protector. That the President's continuous litigation in this matter was unreasonable, and that various statements made resulted in irreconcilable contradictions, citing that the President potentially committed the crime of perjury.